Welcome to the ARCO Forum of Public Affairs. Tonight, our forum event is entitled The Legacy of Civil Rights, a 20-year retrospective discussion of the Voting Rights Act of 1965 and the Civil Rights Act of 1964. Tonight, our moderator is Professor Charles Jones, a visiting professor from Rutgers University. Professor Jones.
Welcome to the forum this evening. The format is quite simple. Each of our speakers will address the following two questions. First, what expectations accompanied the passage of the Civil Rights Act of 1964? And secondly, what is the future course of the civil rights movement, and how does it square with those expectations? Our first speaker is intimately knowledgeable about both these questions, having lived through the experience leading up to both the Civil Rights Act of 1964 and 1965. He was, during that time, the Attorney General of the United States, and it's the gentleman on my far right, Mr. Nicholas Katzenbach. Thank you. Before Mr. Katzenbach speaks, I'd like to just give you a little bit of background. I should have suggested this before. On the Civil Rights Act of 1964 and 1965. For those of you who might not know, the Civil Rights Act of 1964 is probably the most important and far-reaching civil rights bill in the nation's history, designed to end discrimination in public places based on race, color, religion, and national origin. Perhaps the Civil Rights Act of 1875, insofar as it relates to public accommodations, which was invalidated by the Supreme Court in 1883 in the civil rights cases, had the same scope, but the enforcement of the 1964 Act has been monumental and widespread, whereas there's a great deal of doubt about the 19th Century Act and the legislation which followed it. In his State of the Union address in 1964 in January, President Johnson called on Congress to pass the Civil Rights Bill, saying, quote, "We must abolish not some, but all racial discrimination," close quote. On June 22nd, the Senate passed the bill, and on July 2nd, 1964, President Johnson signed the Civil Rights Act of 1964 into law, after congressional action had been taken by the House only hours earlier. The Civil Rights Act authorized by the federal government to enforce desegregation of public accommodations and outlawing discrimination in publicly owned facilities, as well as in employment. Now, several things happened between the Civil Rights Act of 1964 and that of 1965. And I expect that during the course of the discussion, a good deal of the background of those acts will come out. As many of you probably know, there were widespread protests throughout the South, particularly leading up to the Civil Rights Act of 1964, that in Birmingham, which really focused, I think, the nation's attention on the denial of the availability of places of public accommodation and public facilities to persons of color in the South. That agitation and the local response to it and the widespread public reaction really, I think, catalyzed the 1964 Act. Same sort of thing happened between the two acts, between 1964 and 1965, with demonstrations around voting rights in the South again, widespread demonstrations seeking to register people to vote, which led up to the march in Selma, which many of you read about, since the history of that's just recently been recorded in the press, and then the passage of the 1965 Voting Rights Act. The Voting Rights Act of 1965 was enacted with the intention of expanding registration of black voters, particularly in southern states in which they had been excluded from the polls by such devices as literacy tests and poll taxes. Among other things, it authorized the Attorney General to send federal examiners to register black voters in districts in which it appeared that registration was being hindered. At a February 4th news conference, President Johnson declared that, quote, all of us should be concerned with the efforts of our fellow Americans to register to vote, close quote. He pledged to use the Civil Rights Act of 1964 to enforce the right to vote and said, quote, I intend to see that this right is secured for all of our citizens, close quote. On March 17th, the bill went to Congress, drafted with the participation of Attorney General Katzenbach, Justice Department aides, and congressional leaders of both parties. The voting rights bill was passed by the House on August 3rd, by the Senate on August 4th, and was signed into law on August 6th. Now, this forum is appropriate because today marks the 20th anniversary of the two marches in Selma, Alabama, which, as I said, were aimed really at dramatizing the need for federal voting rights law. Recall the questions that I asked at the beginning. Each of our panelists will address them, and we will hear first from former Attorney General Katzenbach.
Thank you, Professor. Addressing the question of what the expectations were in 1963 and 1964, 1965 about the two Civil Rights Acts is a difficult question to really answer because I suspect that people had very different kinds of expectations about it. I was looking at it in a way, a very narrow perspective in the Department of Justice, very focused on what legislation could you get through, and what was important to get through in terms of a number of immediate problems that without some kind of resolution were going to lead to more and more difficulties. It may be hard for some of you today to remember that 20 years ago in the southern states you had something very, very close to a caste system as far as blacks were concerned. And that system, and particularly in a number of rural areas, that system was enforced by law. The segregation was enforced by law, by law enforcement officials, and this had gone on for a very, very long period of time. Professor Jones said voting was effectively denied in many, many areas to blacks. Very few were registered to vote. And Congress had been very ineffective in terms of getting any legislation through. What rights had been secured for blacks were secured as the result of efforts in the courts fought by the Legal Defense Fund and decisions ground through in the way that court decisions do, slowly, dealing with specific facts and specific situations and doing very little to alleviate a very real situation of discrimination. Now let me just say parenthetically so I won't be misunderstood. Discrimination against blacks was not then and is not now confined to a particular geography, to a particular area of the United States. But it was only in the southern states that this really was enforced. The discrimination was enforced as a matter of law, and that's why in the courts you could have some success. But this, the incredible slowness of this process, with all of the leadership that people like Roy Wilkins gave in Thurgood Marshall, and Wiley was involved in this, didn't really get you anywhere. Yet the legislation was virtually impossible because you simply could not, at that time, get a bill through the Senate of the United States because you couldn't get cloture voted in a civil rights bill. The acts in 1957 and 1960, which did very, very little, were enacted because, in fact, the Southern senators filibustering those bills would permit that much to go through at that time, and they're not very effective now. What happened? Well, what happened was that blacks began to take things into their own hands, and for the first time, I think, with Dr. King, you've got real political leadership in an organized way, so that you began getting demonstrations, sit-ins, freedom riders, and all kinds of things of that kind. And this was really the first time that blacks in substantial numbers were asserting and demanding their own rights. And I believe that was a crucial political factor. Kennedy administration, when it came into office, very narrow vote, President Kennedy was elected by, wanted to do something about civil rights. Bobby Kennedy wanted, in the Department of Justice, do something about it, but it really was, in a way, business as usual, because we did it with lawsuits, and we did it in school desegregation matters, and people were discriminated against in voting. You were very lucky if you could get somebody registered before they died of old age. It was a very slow and very difficult process, but they were convinced that there was no possibility of legislation, no possibility of getting it through Congress. And so you had a situation develop which began to be more and more dangerous in terms of human lives, in terms of violence, because you did have people sitting in, being arrested, being tried, being convicted. Then you could go through the process of sort of getting them appeals, and appeals could be won over periods of time. We're now talking months and years. And there were other people sitting in their places, and it was such a situation that got very, very difficult and tense, as it did also with the riders. And yet you had no real way of effectively asserting federal authority there, except for the armed forces. And it was certainly Kennedy's view that this was something they did not wish to do if it could be avoided, for a very simple reason, and that was that if you were going to effectuate any kind of non-discrimination in the South, you were going to have it done by Southerners. You were not going to be able to put in troops to maintain order, protect blacks in their demonstrations, or they would be there forever. Anyhow, as things got to a head, it was really decided, President Kennedy decided he was going to put down a very strong Civil Rights Act, in the hope that it might be enacted. If I can put a parenthetical here, which I think very few people really know about, which is absolutely crucial to the enactment of the '64 Civil Rights Act, and that was a piece of legislation that dealt with a communications satellite. And Senator Kefauver and a group of liberals started to filibuster against the enactment of the bill that President Kennedy wanted, was supported by people like Senator Kerr. And cloture was voted on that bill, and when it came 2 years later to getting cloture in the Senate of the United States, the votes on that bill were crucial, because you could say to people who voted on that bill, you think civil rights, you think communication satellites was more important than civil rights to have a vote on. And you had enough to do it. That was an absolutely crucial point. But I'm taking more time than I should on this. But the effort of the Civil Rights Act, the 64 Civil Rights Act, was very simply, from the administration's point of view, to remove the points of pressure and points of danger which came out of the sit-ins. We had, I think, fairly well resolved through the Interstate Commerce Commission, the desegregation on buses, by getting an order there from the commission that buses engaged in interstate commerce, very broadly defined as interstate commerce is, could not discriminate in the seating of passengers. So this really was public accommodations for the most part that had to be dealt with in that way. And you say, what were the expectations? In a way, the expectations then were simply try to get the points of pressure and the points of immediate pressure removed, so that people could eat in restaurants, people could use public accommodations. And when after a very long and difficult effort, we did finally get it through, and got it through with cloture, and got it through in a pretty good form. Fighting on the one hand, civil rights groups who wanted to make it much stronger, and on the other hand, all of those who wanted to water it down, and the administration sometimes felt very lonely going through that. But the act was gotten through. It was broad, it was comprehensive, much more so than I think any of us thought could be accomplished. And I don't know what expectations I had of that, other than the fact that immediate points of pressure would be removed. The 65 Act was a slightly different proposition. We breathed a deep sigh of relief after we got the 64 Act through and said, thank God, we don't have to do that again. And there we were in 65 back with the Voting Rights Act. But it was much easier after the 64 Act. And that had some specific consequences. They may not be the consequences that we saw them as a way of ensuring that blacks would have some political power, because roughly registered enough to have vote, even though no state, I think, has
better appreciate the necessity for the kind of legislation that we're talking about now. I could almost talk from personal experience. As a black person growing up in a southern state, Arkansas, and having attended segregated inferior public schools, I can tell you that despite the so-called separate but equal doctrine, things were always separate, but never ever were they equal. When my own high school burned in the little town of Pine Bluff, Arkansas in 1939, we said, oh, happy day, we'll finally get a new building. But the school authorities thought differently. There was a program then known as the WPA, Works Progress Administration, so they got some money and decided to rehab the old building and add some wings to each side of the building and order some new equipment. Well, we got the building sort of remodeled, but we never got the equipment because a week before we would occupy the school, all of the new equipment was sent to the white high school, and the equipment at the white high school, the old equipment, was sent to the black school. And that was not only a practice there, that was a practice generally throughout the South. Arkansas took the lead in integrating its colleges and universities. In fact, it did so long before the Brown case, February 2nd, 1948. Arkansas admitted the first black students to the University of Arkansas, and I had the privilege of going to law school there. But when I graduated in 1953, black students were not permitted to even come to the graduation banquet for the graduating class because there was the feeling that you still must maintain some semblance of segregation. I was never a member of the Bar Association of the state because in those days black people could not become members of the Bar Association. I lived in a town that was about 50% black and 50% white. I never knew what it was like to check a book out of the public library because black people could not check books out of the public library. In fact, when my own high school burned in 1939, there was a vacant building, school building, that had been occupied by whites, which was considered surplus, but blacks were denied even the privilege of using that building on a temporary basis while our school was being rebuilt on the theory that there was a possibility that whites might need it again in a couple of years, and once it was occupied by blacks, it was apparently contaminated and could never be made available for use again. When I started practicing law, I went into a number of courtrooms in Arkansas and in Mississippi and in northern Louisiana where black people were relegated either to the balcony of the courtroom or to a separate section of the courtroom. There was segregation even in the courthouse. Indeed, in Little Rock, Arkansas, the capital of Arkansas, there was a separate window with a sign up there in marble, colored and white, to go and pay your taxes. You even had to go to separate entrances to pay your taxes. Memphis, Tennessee, and Birmingham, Alabama were considered the most viciously segregated big cities in the South. Of course, in Birmingham, we had the notorious Bull Connor, who with his police dogs and his whips and his cattle prods, of course, attracted a lot of publicity. Black people voted in Memphis, but they didn't vote in very large numbers in Birmingham. But everything was controlled pretty much in Memphis by the remnants of the old Crump machine. Memphis was rigidly segregated. It's the only city that I know of where even the zoo was segregated. Black people could only go to the zoo in Memphis, Tennessee. I'll be liberal and say they could go 2 days a week, but I think it was just one day, Tuesday or Thursday or perhaps both. But if that day fell on a national holiday like the 4th of July, then black people could not even go to the zoo that day. It was reserved then for the majority race, and so black people would be denied to go to the zoo that day. But never to mind, there was always a makeup, and it had the unlikely name of Negro Zoo Makeup Day. And so in the preceding week or the following week, there was an extra day allotted. You go into courthouses, and there would be signs even on drinking fountains, white and colored. You know, black in those days was a fighting word. And honest to God, once, though I think that it was purely due to just some mistake, but I went in the courthouse in Dawson, Georgia, in Terrell County. And so help me, there was a sign that said white over a large standing ashtray. But now I really think that there had been a water fountain there, but it had been disconnected to have some repairs made, and somebody had just pulled this ashtray over. I cannot believe that really they intended to segregate an ashtray. But these are the kinds of practices that were so prevalent across the South. I remember going to Jackson, Mississippi in the fall of 1961, where I represented 2 busloads of Freedom Riders who descended on Jackson, white and black, and of course they dared defy the segregation laws of Mississippi, and for this they were arrested. In those days, there were only 4 black lawyers in the whole state of Mississippi, and no white lawyer would dare touch a civil rights case. That's why I had to go 250 miles down to help represent them. But I saw something happen that day in court that I had never seen before nor since. We started the trial about 9 o'clock in the morning in the municipal court. We ran for about 2.5 to 3 hours. The facts were pretty well stipulated. The argument was on the law. We did not take a single recess. The judge had never heard from any of us before. He turned to the state and he said, "Anything else for the state?" "No, Your Honor." "Anything else for the defense?" "No, Your Honor." "Very well." And so help me, he reached in his pocket and pulled out a typewritten opinion, finding everybody guilty without ever leaving the bench and without taking the matter under advisement or considering anything. Those are the kinds of things that you ran into. And then down in Baton Rouge, Louisiana, when 2 young SNCC workers, Student Nonviolent Coordinating Committee, 1 white and 1 black, dared defy the segregation laws of Louisiana. They were charged not only with a crime, but they were charged with violating the Louisiana sedition laws. And for that, Sergeant Pitcher, who was the district attorney down there, filed a capital charge against him in which he was seeking the death penalty. Those are the kinds of things that you had to go up against. And then on voting, people say, well, why was it so difficult to vote? Somebody said, well, they had a literacy test. Well, if people can't pass a literacy test, they shouldn't be able then to register or to vote. Well, that may be all right in theory, but in practice, it was found, for example, that black people with PhD degrees could not pass the literacy test because the law said that the literacy test must be passed to the satisfaction of the local registrar. Now, the local registrar might be somebody who only had a 7th or 8th grade education, but still he or she would administer the test and then would determine whether or not you had passed or failed. And a very famous case went all the way to the Supreme Court of the United States, Gomillion versus Lightfoot. Dr. Gomillion was a PhD on the faculty at Tuskegee Institute down in Alabama. And, of course, he could not pass the literacy test. He went into federal court, and federal court ruled that he had a right to register and vote, and also ordered a number of other people registered. And so when they did that, the city of Tuskegee decided that they were going to gerrymander the political districts. Incidentally, didn't the term gerrymander first originate in Boston? I'm not sure about that. But the tactic of gerrymandering is to go in and exclude those that you want to exclude and include those that you'd like to include. And so the districts were so drawn that black voters would not be in a majority in any division, political subdivision in Tuskegee. Well, that case then went all the way to the Supreme Court of the United States, and the Supreme Court said you can't do that. We also had a poll tax in the South. Now, in some states, it was not a very difficult poll tax. In my own state, it was just $1 per year. Somebody might say, well, if you can't afford $1 a year, you don't really need to vote. Well, maybe not, except that there was a very early cutoff date. You had to pay your poll tax by October 1 of each year, and that entitled you to vote in all elections from and after October 1 of that year and the end of September the following year. Well, in those days, nomination Democratic primary was tantamount to election. Democratic primaries were held in the spring. So if you wanted to vote, say, in April or May, if you did not remember to pay that $1 poll tax prior to the preceding October 1, then you simply could not vote. And if you waited until the general election, it was meaningless because the elections for all practical purposes were over with. In some states, in parts of Virginia and in certain parts of Texas, they had a cumulative poll tax, which meant that you had to pay your poll tax for every year that you were a resident of that state from and after you turned 21 years of age. And in Virginia, they had a form for you to fill out. Now, in some places, in the more enlightened sections of Virginia, it was really not too difficult. But in the old 4th Congressional District of Virginia in Southside Virginia, if you were white and you went in to register to vote, they gave you a form, and if you didn't know how to fill it out, the clerk assisted you in filling it out. No problem. You were registered. But if you were black, you were given a blank sheet of paper. The term became known as blank registration. And on this blank sheet of paper, you were expected to know every question that appeared on the printed form, though you were denied the right to even examine the printed form in advance. And if you didn't answer the questions in the exact order that they appeared on the printed form, you were told that you were not qualified and you were not allowed to vote. And then in some places, black people were subjected to questions. They had a lot of this going on in Mississippi. You would be asked foolish questions which required a foolish answer, answers known only to the registrar. How long is a piece of string? How many bars in a bubble of soap? All kinds of asinine questions. And so you say, you know, were these laws necessary? Yes, these laws were necessary. And of course, when one looks around today and realizes that in Tuskegee, the site of Gomillion versus Lightfoot, the mayor is black, the sheriff is black, the state senator is black, the county representative is black, most of the people in the courthouse are black. You got black mayors now in Birmingham and in Atlanta and in New Orleans and in other parts of the South. You say, yes, we've made great progress. I suppose that in those days there was a great feeling on the part of people across the South, particularly black people and other minorities, that at least they could look to the courts for relief and they could look to the national administration. They could depend on the federal government because they were always there willing to fight the battles. The problem that concerns me today is that I see too much of history repeating itself because we went through this same period 100 years ago following Reconstruction when we were making such rapid gains to have most of it wiped out in the infamous Hayes-Tilden Compromise of 1876. You look around today, and black people, by and large, across the South are losing confidence in the courts and certainly losing confidence in the national administration, with a feeling that now the national administration is as much the enemy as were the segregationists of yesteryear. So in terms of what we had a right to expect, I would say that we've become very disillusioned over the past 3 or 4 years.
Our next speaker is Mr. Michael Carvin, who's the Special Assistant to the United States Assistant Attorney General for Civil Rights, William Bradford Reynolds. Mr. Carvin.
Thank you. I'm at a slight disadvantage here because I obviously don't have any person. Can you hear me? Is this on? There, is that better? Okay. I can't share with you any personal memories of the civil rights movement. I obviously wasn't around at that time. I suspect that a lot of the people in this room are in the same position. What I did to try and inform myself and perhaps share with you some of my research was go back and look at some of the statements by the executive branch, the legislative branch at the time of the passage of the Civil Rights Act to shed some light on what those acts were intended to do, particularly in light of what is undoubtedly the most controversial position taken by the administration, the Civil Rights Division, that's affirmative action, and see how that issue has evolved and how it has changed and whether or not it is consistent or indeed inconsistent with the purposes of the Act. It seems to me, in light of some of the things I dug up, that the purpose of the Act and what it was intended to accomplish, and really the only purpose of the Act, if it can be stated simply, was, in the words of John F. Kennedy in his message to Congress concerning the Civil Rights Act, was to, quote, make clear that race has no place in American life or law. So the clear command of the laws was that all Americans have the right to be treated without regard to race, that the personal right to be free from discrimination adheres in all individuals, not in certain groups, but in every one of us. And I think this point was eloquently made and repeatedly made throughout passage of the civil rights laws. I have a quote here from Senator Hubert Humphrey, who was the principal force behind passage of the laws. He repeatedly stated that Title VII, the Civil Rights Act concerning employment discrimination, would prohibit any consideration of race in employment matters. On one occasion he used these words: the title does not provide that any preferential treatment in employment shall be given to Negroes or to any other persons or groups. It does not provide that any quota systems may be established to maintain racial balance in employment. In fact, the title would prohibit preferential treatment for any particular group, and any person, whether or not the member of any minority group, would be permitted to file a complaint of discriminatory employment practices. The other thing I discovered in my research was that no persons were more passionately committed to this colorblind principle of equal opportunity than the leaders of the civil rights movement, the persons who had gone through the struggle that we've just heard about here, who had fought a society structured along racial lines. There's a quote here from Roy Wilkins while he was executive director of the NAACP. He stated his position unabashedly during congressional consideration, again, of Title VII. I quote, "Our association has never been in favor of a quota system. We believe the quota system is unfair, whether it is used for Negroes or against Negroes. We feel people ought to be hired because of their ability, irrespective of their color. We want equality of opportunity, and employment on the basis of ability." I just have one more quote from you, and that's from Jack Greenberg, who was at that time Director Counsel of the NAACP Legal Defense Fund. And his comments reflect what the constitutional command, in the view of the NAACP Legal Defense Fund at that time, was meant to ensure. This discussion came in a Supreme Court case involving a state statute requiring that a candidate's race be designated on each ballot. In his brief, he argued, and I quote, "The fact that this statute might operate to benefit a Negro candidate and against a white candidate is not relevant, for the state has a duty under the 15th Amendment and the 14th Amendment to be colorblind, and not to act so as to encourage racial discrimination against any racial group." The court agreed and struck down the offending statute. I read these quotes not to bore you with ancient history or to illustrate the metamorphosis of some of the positions taken by civil rights groups on this question, but to illustrate that at the time, and certainly in Washington at the time, there was a national recognition, indeed a consensus, that the principle of colorblind was a fundamental legal and moral prerequisite that couldn't be sacrificed, no matter how pressing the concern and no matter how benign the motive behind it. In other words, what the Civil Rights Acts were intended to do was not to benefit a certain group, not to ensure preferential treatment of any groups, but to, as Martin Luther King said in 1963, ensure that henceforth all persons in the eyes of the law and the state would be judged not by the color of their skin, but by the content of their character. What has happened in terms of the expectations, I think, of the 64 Act and how they evolved was that this consensus has broken down. There's obviously bitter dispute as to whether or not reverse discrimination or preferential treatment of groups that have been historically discriminated is or is not consistent with either public policy or what the Civil Rights Acts were intended to do. And I think that in large part, during the 1970s, the evolution was one from equality of opportunity for each individual to an equality of results for certain groups. And that those who had fought so hard for the colorblind ideal had shifted their position to say that the use of race and consideration of race was not wrong per se. It mattered who. You had to look at who was being regulated, who was being benefited, and whose ox was being gored. So that in many instances, it's come down to a clash between the right of individuals, individual rights to be free from discrimination, and the interests of certain groups that undeniably, and as the discussion here tonight has made clear, have been historically discriminated and brutally discriminated against. The position that this administration and this Civil Rights Division has been advancing is that you can't sacrifice the interests of any person on the altar of pursuing group results. That if the understanding that we have to bring to the question is, even though the result we are seeking to achieve is obviously one that is a proper social policy, the question's got to be the means that you use to achieve that result. It's certainly not difficult to understand, and it's certainly not difficult to sympathize with the motives of the persons who were moving society in a race-conscious direction during the 1970s. The goal is obviously to atone for a history of discrimination, and it's not difficult to understand the resentment of groups that have historically been discriminated against when they are now told, after having suffered such brutal discrimination for so many years, that while it was okay to do it then, it's not okay to discriminate in your favor today. That all of a sudden the rules of the game have been changed, and it's no longer okay to take race into account. And our response is essentially that that's right. The rules of the game have changed. They were changed in 1964. We laid down the fundamental principle at that time that you can't give a person a benefit or withdraw one from him on the basis of an irrelevant characteristic, and that's the color of his skin. And to do that is as immoral when you do it to a white firefighter in Boston who has 10 years of seniority and you lay him off, as it is when you exclude a black firefighter from ever getting on the force. It takes on no greater claim to morality because that firefighter happens not to be a member of one of the groups that is allegedly protected by the Civil Rights Act. Instead, it extends to all individuals. So, in our view, the only solution that provides equality, the necessary prerequisite to a just and democratic society, and the only solution that will really achieve a lasting and enduring racial harmony, which I think is what everyone's goal is to stop now. You get beyond racism by saying once and for all, no person will be raised any higher or fall any lower because of the color of his skin. You do not right a wrong that's been committed against one person by visiting precisely the same wrong against somebody else. You do not cure discrimination by spreading the disease farther. So what's the vision for the 1984 and on, and after 20 years of civil rights law? I think that's our vision, that the dream of Martin Luther King, that people will really be judged by the content of their character, not the color of their skin, is realized. That employers engage in affirmative action in the sense that it was traditionally properly understood, reaching out to groups that have previously been disadvantaged, recruiting, training programs that seek to include people, but not quotas that exclude them. And for our own part, civil rights, that means enforcing the laws and that ensuring that every victim of discrimination is returned to his rightful place. And that's the way you get behind our history of discrimination and all the effects that obviously still linger today. Thank you.
Our fourth speaker is Elaine Jones, who is an assistant counsel with the NAACP Legal Defense and Education Fund, and who was formerly a fellow of the Institute of Politics here at Harvard.
Thank you. Thank you, Chuck. You know, ladies and gentlemen, I only have 10 minutes, you know, and Mike Carvin's comments require me really, it takes at least 30 minutes to go back and acquaint him with basic historical fact that he simply shrugs off and says, oh, I'm sorry you've had this 350 years of discrimination, but now, you know, after 350 years of non-color blindness, we must have a colorblind society. And, you know, I must agree with Mr. Justice Blackmun if we are serious about making change, real change in this country, and bringing blacks into the social and economic mainstream, we must first become color conscious before we can become colorblind. Otherwise, you lock people into generations of discrimination. I mean, let's face it. So I don't have to, I don't think, go into that with you, but when Mike says, and I wasn't going to, you know, I asked his boss, Brad Reynolds. Last time Brad Reynolds quoted Martin Luther King someplace, we were together discussing, I said, Brad, please. I asked him, and I don't think he's done it since. I said, I promise, if you don't quote Dr. King, I promise not to quote Ronald Reagan. But he hadn't communicated that to his special assistant, but we'll work that out when we get back to Washington. Mike just said one other thing, and I just have to, he says he doesn't have personal experiences from the civil rights movement, and that's fine. Most of the folk in this country do not have. But all I ask him to do is bring some intellectual honesty to the question. Don't commiserate with me and say, I understand your misery. But in terms of social policy, that's nothing that the federal government and our law can do to remedy. I won't accept that. Now, Wiley talked a little bit about the historical perspective, the importance of the civil rights statute. Because the question comes up. You had the Constitution, you had the 15th Amendment, the 14th Amendment. Why did you need a statute as well? And let me just try to explain a little. You see, this country has not been about the business of seriously dealing with this unfortunate, unhappy question of race for many, many years. We started seriously in 1969 with the Reagan administration in terms of the enforcement mechanism. It took the Kennedy and Johnson administration to get us law, to get it through the legislature. I mean, without President Johnson, it would not have happened. I really believe that. But when you get laws on the books, that's just the beginning. Courts have to interpret those laws. The states are going to challenge the constitutionality of everything Congress has passed. It's going to take a while for the courts to determine what the rights are that have been established. And then after courts work through that issue, then the courts have to determine what are appropriate remedies. Here we are now, for the first time, at the remedy stage, and along comes the administration and say, we're going to be colorblind. Now, he who forgets history is doomed to repeat his worst mistakes. Santiana, he's right. He's right. Now look at 1865. This is the end of the Civil War. Blacks as a group, I'm not talking about individual blacks, married. I'm talking about face, color, skin. That was the least common denominator. Now, the slavery, I mean, it was an awful period of our history. And it's something that this country has to work out of. We have to, that legacy, we have been working at it with some seriousness, as I said, since 1969, but understand the legacy. George Stroud, in 1856, this is just before the Supreme Court decided Dred Scott. Dred Scott came down a few months later. George Stroud, a white man, did an analysis of the basic fundamental concepts underlying slavery in all of the states. Just a few of them. There were 12 propositions of slavery. 12. The master may determine the kind and degree and time of labor by which the slave shall be subjected, to which the slave shall be subjected. The master may supply the slave with such food and clothing only, both as to quantity and quality, as he may think proper or find convenient. 3. Master may at his discretion inflict any punishment upon the person of his slave. 4. All the power of the master over his slave may be exercised not by himself only in person, but by anyone whom he may depute as his agent. 5. Slaves have no legal right or property in things. Now look at 5. And 5 was unique to Negro slavery alone. It's it. Negro slavery, I mean the Phoenicians, the Israelites, everybody could hold property when the slave Greeks, not Negroes. It says now, 5. Slaves have no legal rights of property in things, real or personal, but whatever they may acquire belongs in point of law to their masters. Nothing to pass down. Nothing. 2 types of in this country is earnings and wealth. When you get the Civil Rights Statute in 1965, what it said then was, look, we need equal opportunity on the earning side. It said nothing about wealth. It doesn't reach wealth, the question of wealth. All right, the slave, 6, being a personal chattel, is at all times liable to be sold absolutely or mortgaged or leased at the will of his master. 7, he may also be sold by process of law. 8, slave cannot be a party before a judicial tribunal in any species of action against his master, no matter how atrocious may have been the injury. 9, slaves cannot redeem themselves, nor obtain a change of masters, though cruel treatment may have rendered such change necessary for their personal safety. 10, slaves being objects of property, if injured by third persons, their owners may bring suit and recover damages for the injury. 11, slaves can make no contract. 12, slavery is hereditary and perpetual. Now that's a serious legacy. That's something serious to overcome. All right, now 1865, we get the Civil War over. All right, what happens? The country then does turn its attention to deal with this question. We get the Reconstruction Congress passing what? 13th, 14th, and 15th Amendment to the Constitution. That Congress did it. Setting up all kinds of affirmative action. Howard University, all kinds of the Colored Servicemen's Act. You look at that period, 1865 to 1870. And there you see Congress dealing with it. Although President Johnson did veto a couple of things, but that's all right. It got through and out. And Andrew Johnson, right. And also that's when you get your 1866 Civil Rights Statute. But what happened? We had a period of 9 years. Now, meanwhile, blacks have been enslaved from 1619 to 1863. Over 200 years, 240 years. Nothing. All right, now, we get Congress trying to deal with it, and then what happens? In 1876, as Wiley pointed out, we get the Hayes-Tilden deal. You had troops, federal troops in the South to protect the newly freed blacks. You had a deal cut between the Southern Democrats and the Republicans who wanted Rutherford B. Hayes elected. The Southern Democrats said, we will throw you our support if you pull these troops out of the South. That was the deal. Hayes became president. The troops came out of the South. And that's the period we stopped. That's the period. Beginning in from 1876 up until 1965. I'm telling you, up until 1965. This country not only did not do anything to help blacks out of the country, out of this unhappy state, but this through state action, all of the newly gained rights were stripped from us. The Klan came into existence, the lynchings, the institutionalizing these at-large systems voted throughout the South, the setting up of the Jim Crow laws, everything right through that period. Now, what comes along? Plessy versus Ferguson, as a matter of law, locks it into place in 1896. Well, what happens? 1954 is the first ray of hope. That's Brown versus Board. All right, but that's the Supreme Court decision. That's the law of the land, but who says it's being enforced? That's a lofty, beautiful pronouncement. That is not fact. It's a hope. It's a dream, and it's the law. But thus far, in 1954, empty. At that point, it was brave for the Supreme Court to do it, because this country was not ready for it. White America was not ready for it. All right, so in 1965 was the first time this country spoke through its representative bodies in a loud voice. In this century, we will not tolerate racial discrimination. Now that's 1965. All right. Most of you were being born then, 65, 66, 67. All right. Back to my original question. You had the Constitution. Why do you need the statute? All right. You've got the Constitution. The Constitution means somebody's got to go to court and enforce the right. Somebody's got to find money and a lawyer and plaintiffs, people who've been harmed, judged, depositions, transcripts, bucks, to go to court and enforce those rights, case after case after case. It was being done under the Voting Rights Act, under the 15th Amendment, but no Voting Rights Act. It was being done under the 15th Amendment, but every time you go into court and get one practice abolished, a new one would spring up. and you have to get the money and the plaintiffs and the lawsuits and go back into court. You needed some sort of administrative enforcement, something that the federal government could have a monitoring of voting rights practices, something that wouldn't put the burden on people with nothing to enforce and hold on to their rights. So therefore you get the 1965 Voting Rights Act. That's the significance of it, because the Justice Department is charged with the responsibility of monitoring those places that historically discriminated against blacks. That's why we fought to get a Civil Rights Division of Justice in 1957. It wasn't to look after the rights of white men. I mean, white men have rights, sure. You know, and I don't care how much it's debated. The problem was, ladies and gentlemen, that historically white men had all the rights, and there were none for the rest of us. And so what we're trying to, at this point, you were saying women and blacks and Hispanics and others are saying it is time to share. It is time to share. And they talk about reverse discrimination. It is not discrimination when you have historically had it all. And it's time to share. You're spoiled when you have had it all and are used to it all. You don't know how to give up some and don't understand that you're not entitled to all of it. Because this is a pluralistic society. It is a democracy. Now, we get into the situation where with the 1964 Act, all right, Brown versus Board is on the books. Same problem as you have with voting rights. You have to litigate, go into all of these jurisdictions, school districts, find out students are being segregated. What does it do? 1964 Civil Rights Act, Title VI under that act requires the federal government not to fund any program or activity which has federal bucks. And you know your tax dollars, millions and millions go out every year to those school districts that they need it. And as long as they're discriminating, they can't get it. And that puts the federal government, Health and Human Services, in the business of enforcing our civil rights. I've said enough, but that's why. And we've just begun. In 1969, the concept of affirmative action came up under the Nixon administration. We've had 12 years of enforcing it, and along comes the Reagan administration and said we've had enough. If we don't watch it, we're going to go back and repeat what happened when we abandoned the hope in the last half of the 19th century.
I want to thank the panel for an excellent exposition of the ideas which we're here to discuss. And I would like to invite you now to address any questions you have to specific panelists. And in doing so, please take a microphone either to your right or to your left to pose your questions. Would you please limit your questions to questions? And would you secondly also, if you
in response to that, I mean, if the implicit allegation is that we in any way foster racial hatred, it's quite untrue. And I find it hard to understand how an administration that's consistent theme is that race is irrelevant can be accused of supporting or fostering people judging other people on the basis of race. We do not ensure any minority group a proportionate share of society's benefit. We ensure that no person is disadvantaged because of their skin color, and that applies to all Americans. Obviously, most discrimination in the United States, virtually all of it, is against minorities, so that's where virtually all of our activity is. You don't read about that a lot because it's not very newsworthy. But to say that we should abandon and to say that, as Mary Berry did in the Civil Rights Commission, that white people have no rights is not only wholly contrary to every basic precept of our civil rights laws. That, to me, is the most divisive statement that can be put forth, and it is really an elitist view which lumps all persons, because of their skin color or their gender, together in one group. But there is a diversity among white males, and their rights, like the white firefighter in Boston, need to be protected, and we don't shrink from that task.
Mr. Carvin, I wonder if I can exercise a chair prerogative by defining how I saw the question. I think your first answer to Andy was quite correct. I've seen the documentation, and I know that insofar as the enforcement of 241, the criminal civil rights statute, goes, the Reagan administration has been about the same as the previous administration. The question, I think, though, that Elaine Jones raises is a very profound and serious one, and I think rather than get off on the branch of the tree that you're getting us out on, you might reconsider it. And that is, what about the climate in the country around civil rights and around civil rights in general, and the contribution of the Reagan administration?
Whether the perceptions of persons as racist or others, I fail to take it. I won't have it laid at our door that we've created any atmosphere of civil rights. I think the only way you create a good climate of civil rights is to say, let's end it now. Let's not continually turn racial groups into battling forces trying to grab ever bigger shares of a federal budget or any other pie that's being offered by our society. Let's treat people as individuals. That's the climate that I think is here. I certainly think that anyone who escalated the rhetoric over this issue is not going to make it extreme. You've been certainly volatile attacks by persons who have a different view, and I think reasonable people can obviously differ on this question. But to say that animosity is due to statements of principles that under any standard have to be considered quite reasonable and quite rational is to turn a person who is being attacked into the person responsible for the controversy. And so I don't think that we are responsible for any racist climate in the United States.
I know. I am absolutely appalled, sir, at what I regard as a total lack of understanding of what the problem is. The problem is not to persuade white males who are going to treat the people.
in, fought for, that Bobby Kennedy stood up in front of Congress and said quotas were absolutely against them, and nothing in these statutes requires or permits a racial balance. And then to say that because 20 years later a new administration comes in and espouses precisely the same philosophy, doesn't understand the problems in America, I think is wrong.
Well, I don't think it is wrong, sir, and I will try to explain it to you. When Hubert Humphrey said the principle is to be colorblind, what do you think that meant to the people he was talking about? It meant you have got to stop doing what you are doing. That's what it meant. When you say today, oh no, we have to be colorblind, what do you think it means in today's world? You know what it means? It means we want to return to business as usual. We don't want to get to the end of this road. Now, if that's not what you mean when you say it, then for God's sake, find a way of communicating.
If to say that you should treat people... If to say that you should treat people equally is perceived as meaning you should discriminate against persons, I think the problem lies in the audience and not in the speaker. And I think it's wrong to attempt to intimidate and say that persons shouldn't espouse what, by any rational standard, is an extremely reasonable viewpoint, because that may be misinterpreted and distorted by others. And what can I say other than this is the message that was espoused by the Justice Department in 1964, and it is the message that we are going to continue to espouse.
I have some
I'm
knowledge
gonna,
of what it was in '64, sir.
Let me request additional questions, not along the same line. I think that question's probably been answered as far as it can be answered at this point. Yes, the young lady here.
This question, I think, is aimed at Mr. Katzenbach, but anyone who would like to answer. I'm not sure whether any of you have read David Garrow's book, but I'm curious to what extent you think the media, and particularly television and photographic news coverage, played a part in the passage of especially the Voting Rights Act in '65 and also the Civil Rights Act in '64. Garrow went through and read all the transcripts and tallied up the references to these actual visual images, and I'm curious whether you who were around at the time were as impressed by these graphic representations, and whether that was a major force in bringing to people's awareness the extent of the situation, especially in Selma.
I have no doubt that it was a very major force.
You personally, we weren't around then.
I mean, I know, I personally have absolutely no doubt that it was a very major force in having because I think that before television and before the demonstrations that you had and the number of newsmen and camera people and everybody were there, I think there was really very little understanding on the part of the rest of the country as to some of the things that were going on in the South. And I think, I think that if you really wanted to give credit to somebody for the enactment of the Voting Rights Act, you probably ought to give it to Sheriff Clark.
For
Undoubtedly.
looking so bad on television to the entire country, is that it?
Yes.
Yes.
I want to interrupt. I understand that Mr. Kassenbach has to take a plane fairly soon, so I think if we can excuse him now, I'd like to thank you especially for your comments and your answers. We do have about another 10 minutes to continue the question and answer period. So, question from this side.
Yeah.
action is, doesn't go, and I don't want to sound like a lawyer here, but it's the only way I can explain it, doesn't go to the question of liability, where there's liability. It goes to the question of remedy. Once there is a proven violation of the law, whether it's constitutional or statutory, then as a remedy, what can the court do? That's been a wrong is usually found before an affirmative action remedy comes into place, or the party sitting down, as in Weber, realizes or admit to one another that there's been a historical exclusion of blacks. The wrong in that case is admitted, and then they use affirmative action as a remedy to right the wrong. So it's the point at which it is being used, and it is only used in certain cases, in extraordinary situations where there's a proven history or admitted history of discrimination. I don't know if that's the best I can do with it.
That adequately respond to your... Fine. This gentleman?
One prefatory. This is directed to Mr. Branton and Ms. Jones. Would you admit that affirmative action in certain instances hurts whites, white male, white women, hurts them, denies them of opportunities solely because of their race, regardless of the reason for it?
In certain instances, it helps, such as Weber versus Kaiser Aluminum in that training program. Whites entered that training program who never would have been in it.
Fine, but would you admit that in certain instances, whites will not be hired or will lose their jobs in layoffs, say?
No, they will not lose the job. The Supreme Court has made clear that in terms of when there's an affirmative action plan and seniority, that seniority takes precedence. It did it in 1977 in Teamsters, and it did it in Starts last year.
Did you agree with that decision?
Well, let's see. Before we start having a cross-examination and lengthy exposition, you're leading up to a question,
okay,
aren't
my
you?
question is this, is that don't we as a society as a whole go down a tough road when we go from individual rights to group rights, individual wrongs and remedies to a class-wide, group-wide wrongs? And the reason I say this is not just because of the black-white situation, but don't we have a situation in this country today where you see other groups sort of, in some instances, going out of their way to, in a sense, prove they have historically been discriminated against in order to get some perceived benefit by being seen of as a minority. Now, women have been discriminated against, no doubt. Gay people have been discriminated against, no doubt. And then, but I've even seen instances where people have claimed because they, whether this is serious or not, because they were born with an alphabet, a name, bottom half of the alphabet, all during school they were last. This hurt them psychologically. I mean, my point is, don't we, when we start doing this in a society which obviously the pie can't keep growing and growing, eventually going to get in a society where we're constantly at odds with each other in a very divisive situation, the exact opposite of what race relations and that type of society we want.
Sir, yours is a very serious question, and I do appreciate it. And you're right in that this is not an easy question. It's a complex question, and I'm not sitting before this audience saying in each and every case an affirmative action remedy is appropriate. In many cases, it is inappropriate. All I'm saying is that there are some cases, extraordinary cases, in which the remedy is appropriate, and we shouldn't root it out saying no matter what the circumstances, what the facts, what the evidence, that is a remedy that can never be used. All right, that's first. All right, now, as to your question about group rights and group entitlement, sure. I understand the trouble that presents in terms of our view of this society and where we want to go as a people. But also, we are at a point in history where we come into situations where, as a people, the courts have got to be able to fashion certain remedies for the protection of both blacks and whites alike. Now, just let me give you an example. Briefly, I'll try to make it brief. Coleman Young became mayor of Detroit in 1972. Detroit was known as a murder capital of the country, murder city or something they called it. A predominantly white police department, 90% white police department, and an over 50 majority black city. some 6 to 8 policemen losing their lives every year in the line of duty. Coleman Young had a social problem. The whites in the city of Detroit, the blacks in the city of Detroit, is an unhealthy atmosphere. Blacks were not in the police department because they had historically been excluded. What did Coleman Young do? Adopt an affirmative action plan. He said for every white he would hire in the future, he would also hire a qualified black, which is what he did. From 1974, the time that affirmative action plan was adopted, until 1981, not one policeman lost his life in the line of duty. Not only that, Mr. Brad Reynolds then comes into Detroit to upset the affirmative action plan, to challenge it. And the Sixth Circuit said, no, we affirmed it. Well, after the Justice Department tried to throw out the plan, Detroit was a model city. The Attorney General of the United States, not the present one, the one that just left, Attorney General of the United States, Cole had the police chief of Detroit came to Washington and gave him an award for running a model police department in a model city. So, the left hand ended up, but that was an affirmative action plan. And that is one in a hiring situation that benefited both. And affirmative action plans do that when they're delicately crafted. And as the court said, was it Weber? When the plan does not unnecessarily trammel the interests of white workers.
Thank you.
We have time for just one final question, and we have one final questioner. Sir?
Mr. Carvin, I was wondering, you spoke extensively of the opportunity issue. If you're going to do away with affirmative action, how do you propose to equalize opportunity, which I can't believe that you believe is equal today? You represent an administration which is proposing cuts in education, which is proposing tuition tax credits, which would benefit private schools at the expense of the public schools. How do you propose to go about equalizing opportunity so that once they get into the workforce, they will have true equality of opportunity and therefore be competing on an equal basis, making affirmative action unnecessary?
Is your question, as I understand it, how can you have equal opportunity if there's no federal support for education and other benefits? Or right.
Why don't you, would you, since the discussion is being recorded, would you rephrase your question?
I thought it was fairly well phrased in the beginning.
I thought it was too, but maybe you might want to just...
Does the question go to discrimination or education? Was the thrust of?
I think they're related. I think they're distinctly related.
Yeah,
that's what I meant to imply, and I think that's true.
Yes, but certainly that's exactly right. And I think it's very important that education be provided on an equal basis, like all other bases. Does that mean that a denial of education is a denial of a particular group's civil rights? I don't think so. I think a denial of education affects everyone equally. I think that to the extent that you have a dispute with the educational philosophy of the administration, which is attempting to return, in many instances, to local control, after the 15 years of probably the most disastrous educational performance, as the federal government increasingly increased its role in educating our youngsters.
But we saw what local control did in the South before the Civil Rights.
And that's my question is, are you talking about education or discrimination? If you're talking about equal facilities, which are never, again, to be separate, I fully support it. If you're saying that someone has a civil right to federal involvement in local education, I don't think so. And I don't think it is at all inconsistent with providing equal opportunity to return to the state and local governments a major educational role. But my main focus is that the problem with civil rights thinking today is that social welfare programs like education get confused with basic entitlements to equal treatment. That is not a civil rights issue. And you and I can debate all day. And I think that when you do that, and then you select them on the basis of their ability, not on the basis of their race. And then when you have training programs by the employer once they get in, that as night follows day, so will equality of results for the black community become a reality. But
Okay.
Thank you very much.
Could I just ask Mr. Carvin one question to close this out?
I think you can, sir. I think you should.
Well, I don't know the answer to this question. 30 years ago, come January, I personally went into the United States District Court in Little Rock and filed a lawsuit on behalf of black children in Little Rock, which led to the desegregation of Central High School. In 1957, when some white people created a mob action down there to try and block the admission of these kids, led on by the then Governor Faubus, President Eisenhower sent federal troops down there to protect the kids. That litigation's been going on now for over 25 years. There are 3 school districts in that county: Little Rock, North Little Rock, and Pulaski County. A year or so ago, the Little Rock School Board, which had always been the defendant in the case, finally decided that in order to achieve maximum racial integration and harmony in that entire community, they went into the federal court and filed a lawsuit against the other 2 school districts, asking a federal judge to consolidate all 3 school districts. I went back into that case last summer and participated in it. And the federal judge ruled that because of the historic segregation in all 3 districts, because of the fact that the Little Rock School District had, to a greater extent than the others, tried to comply with the law, because white residents were fleeing the Little Rock District to avoid greater racial integration, because of the participation of the developers and the builders and the housing patterns and the redlining of for loan purposes and whatnot, the only remedy was to consolidate all 3 districts so that there'd be really no place to hide. That case is now on appeal to the United States Court of Appeals for the 8th Circuit in St. Louis. I understand that this week the Department of Justice decided to file an amicus brief in that case. Sir, I would ask you, what position is the Justice Department taking now in that case?
Well, I participated in writing the brief. The position essentially was on the basis of incontrovertible Supreme Court precedent that the fact that busing has failed, which it has, you're quite right, in Little Rock, as many mandatory transportation remedies fail, does not authorize a federal court to exercise what he views as a socially desirable end and to incorporate every suburban district in the area. The Constitution clearly requires that you exercise a violation only when there has been an effect between the 2 interdistricts. I won't go into all the specifics, but it's precisely what happened in Detroit, as you well know, and when the Supreme Court said, yes, the Detroit school district is 85% black. No busing plan is going to work here. And what the district court judge did there is precisely what the district court judge did in Little Rock. And so he incorporated all of the suburban districts and made them one huge school district where that judge, one man, would become a superintendent over 86 different municipalities. The Supreme Court said, that may be a good result, but you are not the organ of government that does it. What you do is enforce the law, and if you find a violation, you remedy it. But simply because you think there's a problem doesn't give you the warrant to usurp the legislative processes in Michigan. And I saw no distinction then, and I see no distinction now between the Detroit case where the Supreme Court laid down that very clear message and exactly what's happening in Little Rock. And that's why we filed on behalf of the suburban district.
I'm disappointed.
On that rather sour note, let me thank all of you for your time and your attention at this forum, and invite you to come again.